Dobar dan, dragi moji prijatelji iz Australije. Good afternoon, everyone participating at this conference. I'm honored and privileged to have been invited to represent Australian court interpreters at this conference dedicated to interpreters and translators during COVID-19 event and organized by the Serbian Court Interpreters and Translators Association in Serbia. My name is Silvana Pavlovska and I have been practicing translation and interpreting in the Serbian, Macedonian and Croatian languages for nearly 40 years. I hold a Bachelor of Arts degree in Interpreting Translation and also a postgraduate degree in journalism from Australian universities. I also own and operate Language Experts Proprietary Limited, a national company providing interpreting, translation and linguistic services to both government and private sector clients. I have developed and delivered the Legal and Court Interpreter and Translator course and the Police Interpreter and Translator course, and also taken part in a number of conferences in Australia and internationally. My preferred area of interpreting and translation is court and law enforcement. And due to my experience and industry involvement, I'm very well placed to be able to talk about matters related to court interpreting and translation in Australia. My presentation will provide you with some information on the topic of COVID-19 restrictions and how they have impacted on the work of court interpreters and translators in this country, the responses and the changes, as well as some proposals for solutions to the challenges. In Australia, professional interpreter and translator services have been in existence since the early 1970s, during which time we saw the introduction of training at TAFE colleges and later on at universities, and the establishment of NATI testing body. Interpreter and translator services are mostly provided to government, which delivers its own services with an assistance from an interpreter and translator. Such services are provided in accordance with the Commonwealth Government's policies on access and equity, that is, access and equity, and in line with the multicultural policies. This means that the government has a commitment to provide services to disadvantaged persons who are unable to communicate well in English when they are dealing with government and government-funded organizations, which includes, of course, public courts. Interpreters in all government settings are normally engaged where a person has difficulty understanding English or is deaf, and this affects the person's capacity to understand their rights and their obligations and inhibits their ability to communicate with court or tribunal. In a court or tribunal, the need for interpreter assistance is assessed on a case-by-case basis. The need for services is determined by a number of things. First of all, asking the person if they need to access an interpreter. Secondly, assessing the person's speaking ability to ask questions that require a narrative response or an explanation. Thirdly, assessing the person's comprehension and communication ability by asking questions that engage that person. The National Accreditation Authority for Translators and Interpreters in Australia works with industry professionals to set the minimum standards of performance across several areas of competency. A certification test assesses the candidates against those standards, and the candidates who demonstrate that they will meet the standards are awarded a NATI certification. For court purposes, the appropriate level of certification is the Certified Interpreter or Certified Translator level, which is the first professional level. Practitioners who provide interpreting and translation services in court must provide the certification level, their qualification and experience when on assignment. Certified interpreters must adhere to the Code of Ethics and the Code of Conduct developed by AUSIT, which is the National Australian Institute of Interpreters and Translators. And this Code of Ethics and Code of Conduct has been unilaterally accepted Australia-wide. Most interpreting in court proceedings takes place on-site in a courtroom. However, since the start of COVID-19 in March 2020, there have been drastic changes to the method of delivery of interpreter services. During March and April this year, in some jurisdictions, interpreters attended courts in person. However, since May this year, the methods of delivery have been via telephone and video conference interpreting. Telephone interpreting, as we all know, doesn't allow the interpreter to be seen or see people in the courtroom, whereas video conference interpreting does allow visual representation of all the parties. It appears that the courts in Australia have favoured the video conference interpreting method more than telephone interpreting since March this year, as they have been using video conferencing facilities that transmit and receive both video and audio and can be dialed by the courts, just like in the ACT or the Australian Capital Territory courts and tribunals that are using either SIP address, something that looks similar to an email address, or they are using an ISDN, which is something that looks like a telephone number. And these arrangements have been put in place well in advance of any proceeding. In criminal matters, in the ACT courts, for example, interpreters are managed by either the Commonwealth Director of Public Prosecution or the ACT Policing. And this is for witnesses and defendants in the ACT Supreme Court and the ACT Magistrates Court. Matters that relate to protection orders are arranged by the Magistrates Court. In civil matters, appeals and other criminal matters in the courts, parties are required to organize interpreters at their own expense, including for witnesses which require interpreters, or who require interpreters, to be more precise. During COVID-19 lockdown, demand for interpreter services, as already mentioned, declined drastically. Many of the pending court hearings where interpreters were assigned to interpret the proceedings were required to be converted to telephone or video conference interpreting assignments of the same duration as those for on-site interpreting assignments, that is, half-day booking or full-day court booking. This necessitated interpreters to work from home as the courts closed their doors in line with the government restrictions. Furthermore, interpreters all of a sudden faced with enormous challenges when working from home, providing either telephone or video conference interpreting. Working from home is not a very suitable environment, as all our other members of the family are also at home, including pets, distractions, noises, issues with internet connection and specifications, necessary training, and so on and so forth. Interpreters had reported that working from home makes life very stressful and also pretty lonely, as they are isolated and have no contact with other interpreters. Interpreters' incomes plummeted also. Interpreting and translation services in Australia are considered to provide or are considered as essential services in many areas, including the courts. So those practitioners who have been attending on-site assignments in jurisdictions where they are allowed to do so reported that there are no specific guidelines for interpreters for interpreter practice during COVID-19. Interpreters reported that there are general guidelines that all persons visiting the court must comply with government restrictions, things like physical distancing and increased hygiene standards, but that was all. In the general guidelines, the ACT Magistrates Court Practice Direction of 2nd of January this year states that only those persons with a direct interest in the proceeding being heard are allowed to be in the designated courtroom. Parties for any other matter must not enter the room until invited to do so after the preceding matter is completed and any hygiene requirements have been attended to. The courts in the Australian Capital Territory in particular have resumed their usual business recently, with all hearings in person, subject to some exceptions, which include the use of telephone or audio-visual link. Based on our online research, the only interpreter guidelines we could find were the United States of America, titled Where Telephone or Video Conference Interpreting is Being Used, Best Practice Guidelines. Other than the physical distancing and the personal hygiene requirements, interpreters working on-site in courts are still able to be briefed and carry on with their normal duties in the courtroom. However, those who are using telephone or video conference portals do not have this same opportunity. Some practitioners have stated that they would prefer video conferencing over face-to-face when they're attending court proceedings. In-person or face-to-face interpreting has indeed its advantages and also its disadvantages in the courtroom. The disadvantages are due to the physical connection or lack of it and a potential risk to the health and the well-being of the interpreter. Currently, due to the different government restrictions in every state and territory in Australia, brought about by the lack of federal and state government guidelines, there is a combination of delivery of interpreter and translator services. Some services are provided on-site, whereas others are provided on the phone or via video link. In the state of Victoria, the Department of Justice and Community Safety announced a summary table of audio-visual link and audio link requirements during COVID-19. The new health and safety measures announced on the 17th of July this year for all Victorian courts and tribunals are: anyone in Victoria's courts or tribunal buildings will be expected to wear face masks. Secondly, if people are physically distanced and stationary, they can remove their task, dispose of it and replace it with a fresh mask when they move around again. Thirdly, disposable masks will be available to all court users attending for hearings or the registry in person. The masks will be available at entrance points before security screening. They also say, please allow or follow the continuing health advice, including physical distancing of 1.5 meters away from anyone you do not live with. Practice excellent personal hygiene at all times, washing hands, cough and sneeze into a tissue or your elbow, and if you feel unwell or have symptoms of COVID-19, well, you do not attend court. At the Magistrate Court in Melbourne, the number of video link hearings has doubled to a recent peak of 244 a day as a result of this pandemic, according to the Australian Broadcasting Commission court reporter Karen Percy. We have transformed what has been largely a paper-based court to a court that is now hearing WebEx hearings, said Chief Magistrate of the Victorian Courts, Lisa Hannon, referring to the online meeting software. The Chief Magistrate went on to say that every change to the system had been carefully considered. Before the pandemic took hold, 2,000 people went in and out of the Magistrates Court in Melbourne every day. Now the traffic is about 1/10 of that. On any given day, only half of the rostered magistrates are working at the courts, with the rest working from home. Only the most urgent cases are being heard, such as bail applications and plea hearings, as well as cases involving those in custody or people making family violence applications. Some lawyers and some prisoners and those who are in remand are still attending court, but only if physical distancing can be achieved. The Supreme Court of Victoria has had to change how it hears its cases, also to comply with the social distancing restrictions. Across the varying court jurisdictions, there has been a rapid and radical shift since the pandemic began, as large sections of the work of the courts has been moved online. The Criminal Bar Association of Victoria Vice Chair Sally Flynn, QC, said there had been problems with the number of links available and time restrictions that applied to video conferencing. Certainly it's difficult when you don't have ready access to your client, for example, if we are dealing over video link or an instructing solicitor, said Ms. Flynn. The biggest change is that jury trials have been suspended because of the risks of having groups of people together for extended periods of time. Emergency legislation does allow judge-only trials, but defendants have to consent to a judge-only hearing. Victoria Legal Aid, which is the government-funded legal organization, the Director of Criminal Law, Dan Nicholson, said, "For our clients who have disabilities or require interpreters, it can be harder for them to participate in these hearings when they're done remotely," he said. The Supreme Court is upgrading its technological capabilities to host more web-based hearings, allocating staff to help set up virtual hearings. While lawyers agree the system under COVID-19 as it stands is not perfect, some say the courts needed to change before the pandemic struck. Interpreters and translators providing remote interpreting services in courts under the current restrictions are expected to be available either half-day or full-day and are being paid less than those providing on-site interpreting services. Currently, there is a move for the fees to be improved due to the nature of the assignment and the concentration required. Professionals Australia, the Interpreter and Translator Union, are aware of the current situation, and they have expressed their concerns regarding the engagement of interpreters during the current extraordinary circumstances precipitated by COVID-19 pandemic. In a recent statement, the union expressed their concerns about the safety of interpreters and the very poor working conditions and rates. The whole COVID-19 event and its effect on practitioners in Australia has indeed been overwhelming. Some practitioners have been able to cope with the changes, whereas others are finding it hard and difficult. There is some government financial assistance available for those who meet the criteria. There are many practitioners who do not meet the criteria and are in financial strife. Given the unprecedented experience practitioners have been subjected to, in my view and in the view of language experts, it is paramount that these services continue to be provided. The courts recognize the vital and essential services interpreters and translators provide, and they themselves recommend that the courts should continue to pay the interpreters at the same rates previously paid for on-site interpreting. It is hoped that the working conditions and the rates of pay will improve as interpreters and translators in Australia are regarded as essential services, particularly in the courts and tribunal settings. We will see more and more of the services being provided via telephone and video conferencing portals, with some on-site interpreting in some places. Practitioners will continue to use and search for new online technologies to enable them to provide services. They will continue to educate and train themselves because education plays a major role in improving and expanding their skills, including training on how to use remote video conference interpreter technology in a much better way to deliver quality services. If one can draw one positive aspect from the COVID-19 pandemic, it will be that it provides an opportunity for resetting of our profession for the benefit of all. I thank you all for your attendance and for listening to my presentation. Thank you.